proceeds. My Lord, let me make a distinction. This is not an application for extension of time, as my colleagues for the three respondents seem to suggest. The time fixed in the Constitution is for filing the petition. And then amendment is an entirely different procedure following the filing. So the petition was filed within the time frame. And I'm fortified by the submission of the learned Attorney General when he gave the background to how we got here into the extension etc. My Lord, the complaint was not about time for filing and arguing a petition. The recommendations of this court related to the entire electoral process. Now, complaining that 3 days is given to the respondent, I think, I don't know if it were permissible.
Restrict yourself to the new matters.
True, my Lord, and that's what he raised. The Attorney General raised this, my Lord.
That is just a counter argument. That's not a new matter.
Most obliged.
They argue, you are lying. They argue.
If you had only, most obliged, my Lord. If you had only permitted, my Lord, I would simply say that they were satisfied with the 3 days. That's why they never complained in previous petitions. After all, he makes the rules, and he's happy with them. My Lord, earlier on, I had...
no, let me take you back a little.
Yes, my Lord.
You said you're not seeking extension.
No, my Lord.
What was the whole purpose of saying he was under disability?
The disability, my Lord, relates to the time taken away. And with your permission now, I can answer their question.
You want back, not so?
No, I'm not, my Lord. The argument from the respondent has been that actually the applicant stroke petitioner has had more time than in previous petitions, which necessitated the previous amendment in the Amama Mbara's case. It is on your record now that even when the law gave him the 15 days, the third respondent, in more particular terms, took away 10 days, and that would still defeat the purpose of the rule.
So what do you want then this court to do?
To permit...
To consider the 10 days he was under disability or not? You're not, that's not
my Lord,
right.
thank you, my Lord. With your guidance, to consider the circumstances.
It can't be my guidance, it should be your case. What is your
My case is this, my Lord. To consider the 10 days of disability as having disabled him to put his case effectively and effectually before this honorable court. And therefore, now that he has his freedom and he has identified the gaps in the process, that's what he wants to present to this court.
In other words, you want the 10 days to be considered?
To be considered,
or you're not courageous enough to say?
Well, my Lord, courage in this court is guided by courts and the regulations.
By the law.
Yes, I am courageous enough, my Lord, to say, consider those 10 days.
Let me tell you, the submission, if I got it right, I don't know what my learned brothers and sisters see. The case for the respondent, that there are matters which you raised, which were not raised in the original petition, but which you are now raising after the close of the limitation period. In other words, say you could not raise them after the 15 days.
Within the 15 days, my Lord.
You can only raise them within the 15 days.
Yes, my Lord.
And then after the first, you can't raise them.
My Lord,
we are submitting. That is the crux of the submission from the three respondents.
My Lord, yes, except to
and I understood you to be saying, no, yes, I'm raising some of these things after the first. This is because the petitioner was disabled. Give us more time.
My Lord,
you are now saying, please.
My Lord, your entire observation is correct, except with your guidance. I don't want to use after the word limitation, because my understanding is that limitation related to filing. Otherwise, the rest of your observation is correct, that I need to recover that time to put my case properly before court. That's what I'm saying.
In other words, Counsel Segona, you admit that you are raising new matters which were not raised in the
yes, my Lord.
petition.
My Lord, that is true.
And it is your case that these new matters were not within the possession of your client by the time you filed the petition. So
the circumstances
have included them in the petition.
My Lord, the circumstances did not permit him to prepare adequately and place them in the petition. And now he's able, and he has been able to place them before your lordships for consideration.
What do you mean prepare adequately? You see, Council, maybe I'm lost, maybe you're losing me. I understood the line of your argument in your main submission. There was a response. You sought to strike out the affidavit evidence, count reading by Learned Counsel Kihika. Yeah? But of course, the court might agree with you, but it could also disagree with you.
Sure,
If it declines to agree with you, then there is evidence by Learned Counsel Kihika. Similarly, there's evidence, I forget by who, for the third respondent. The one which attaches, yes, the one which attaches evidence that yes, and the Attorney General does not deny that there were restrictions on the petition. And I thought these are the issues we dwell on.
Yes, my Lord.
For some strange reason, both sides did not. That, look, there were restrictions, yes, but the restrictions were not absolute. Here's the evidence. His lawyers were visiting him. His other members of the parties were visiting him. Here's the register. I thought I saw something like this.
Yes, my Lord,
so when you address us on disability, I thought this is where we want to.
That's true, my Lord, except that the applicant.
I'll give you 3 minutes for that.
Thank you, my Lord. My Lord, the applicant has gone ahead to reject.
This is what we call handling every matter in controversy before court. I'm giving you 3 minutes.
Thank you, my Lord. My Lord, the applicant has rejoined on that and indicated that even those said visits by those few people related to his freedom. He was concentrating on his freedom at the time. So he has answered the Attorney General to that extent. So, my Lord, the argument here is that I am avoiding using the word guidance because I've been guided. The argument here is that, one, the 10 days were taken off. And because those 10 days were practically, I was deprived of those 10 days practically, I could not concentrate to effectively put my case. That explains why there are some new matters in this. And relying on the authorities I presented earlier, my Lord, even new matters are permissible. That is the whole essence of amendment. Amendment is not about clerical errors.
That one you submitted, we have on record, we will consider.
Thank you, my Lord.
So that one you submitted, and they hold a contrary view, so it's now our duty to find out who we think is stating the law as we understand it.
Yes, my Lord.
Yes.
I think I have also submitted on the alleged prejudice that is likely to be suffered.
Can you address us on this? One of the matters which we raised, there was this thing of the first respondent was not qualified, something like that.
Yes, my Lord.
I saw it in the application.
Actually, the attorney, by raising the issue that the first respondent was not qualified, and we have made specific.
You raised it and said it was illegal, under illegality.
Yes, my Lord. We said we made reference.
My question is this, Councillor Bega. My question is, when did the petitioner discover that illegality? Was it when it was under disability, or from the first day the first respondent was nominated?
As soon
when
as
was this illegality?
My Lord, during the course of preparation, after filing this petition.
Well, that's when he discovered.
That's when he analyzed the constitution and found out
that the first respondent did not qualify to contest.
True, my Lord, and these are matters of law. They are in the constitution. So somebody cannot state.
Was the law passed when it was under disability?
No, no, my Lord.
Yeah.
But it's an illegality we are bringing to your attention, and it is the duty of this honourable court, if I may use the word, to investigate that illegality.
Councillor Bega, you know, I want you to be of use to your client, the petitioner. This court wants to be absolutely, and we took oath to do that. To be fair to the parties, we will not be more fair to the petitioner than to the respondents, and vice versa. The parties, fortunately, both parties, the 4 parties are our clients. For you, only the petitioner is your client. And this thing, landed council appearing here are representing the specific lands who have been instructed there. But the courts of judicature, the Supreme Court of Uganda considers all these four our clients. And we're not going to take sides, we're not going to favor any one of them. And that's why we even bent backwards to really to seek to find out from you. Because the issue of the first respondent not qualifying, and that's how you put it. Confession, otherwise you should not have been a candidate. That's my understanding. When did the petitioner realize? He realized after release from...
My Lord, I have stated that when you look at paragraph 4 of the original petition.
Oh, let me put it differently. When ought he to have realized that this one does not qualify?
In the course of preparation, my Lord, after the filing of the original petition,
okay,
which contained the clause in paragraph 4L to the extent and effect that, contrary to Article 62 of the Constitution of the Republic of Uganda and Section 13 of the Electoral Commission Act, which has been referred to, the second respondent compromised its independence by subjecting its functions to the direction and control of the first respondent, state organs, agencies, and security institutions. Now, the intended amendment clarifies this and says, by the way, this gentleman, the first respondent, did not even qualify by virtue of this.
Mr. Lubega, isn't it true that this amended petition is actually a response to the respondent's answer to your petition? Because it appears they pointed out some loopholes and weaknesses in your petition, and now this is an attempt to strengthen your case.
My Lord, thank you. I have actually asked for the documents themselves to look at the chronology. You're going to find that by the time we filed this application, we had not been served with, for example, the first respondent's answer.
No, that's granted.
So we had not.
But the second and third must have served you already.
But to be specific in answering my Lord's question.
And to help you, we took the decision that you will be served by court, so that there is no delay done.
My Lord, to specific.
And I know whenever we received those things, the service was instant, except for your last document, which appeared after 6 on Saturday. You remember?
Yes, my Lord.
I had to make a decision not to close this court, which I should have done at 5 o'clock, and wait it to you up to 6 o'clock. That's the only time when we could not serve, or service could not be done at the same time.
My Lord, actually, that have been taught to thank with caution, yes.
You're not thanking me for extending the time beyond the working time.
That's why I'm saying I've been taught to thank with caution. That is exactly, my Lord, the position. It is not possible that we could receive the respondent's answers and immediately come up with this kind of application within those limited hours or minutes. No, we prepared this application prior, and if court will indulge me, there were even several requests. Maybe we file on Monday, and then court orders no, you file today. So to answer specifically.
No, that's not true. You wanted to file on Friday. The only reason you could not file on Friday was because you were asked to make an application. And the last time I was in practice, making an application takes 30 minutes. A notice of motion.
In fact, my Lord,
you have a template in your computer. You just...
That, my Lord, fortifies my answer to the question by the Honourable Justice.
Understand you. Can you deal with the other?
Yes, we were not.
The other new matter, which
yes,
we
were not firefighting, and we are not responding, my Lord, to that.
So deal with the last.
Well, the last one, my Lord, is where I have landed following the questions here, without prejudice to my plea and admission of irregularity in the affidavit my lord, of Tuliam Sima, and the affidavits stated to have been filed on 6th, yet the swearing was done on 8th. My lords, permit me to rely in persuasion on the authority of Sagu versus Roadmaster Cycles, Uganda Limited.
Is it on your list of authorities?
No, my lord. Like I said, I stamped on it in the course of the standover.
Sagu, did you say?
Sagu is S-A-G-G-U versus Roadmaster Cycles, Uganda Limited. 2002, Volume 1, East Africa, page 258. My lords, at page 3 of the Court of Appeals judgment to page 4 is where I seek to find fortification that it is tried law that a defect in a jurat or any irregularity in the form of the affidavit cannot be allowed to vitiate an affidavit in view of Article 126(2)(e) of the 1995 Constitution, which stipulates substantive justice shall be administered without undue regard to technicalities. I should perhaps mention that the jurat is the short statement at the foot of the affidavit indicating when, where, and before whom it was sworn. It would follow that the land judge had the power to order that an undated affidavit be dated in court, or that the affidavit be resworn before putting it on record. He was also correct to penalize the offending party in costs, and made reference to ex parte P. Harris L.R. and Ibrahim versus Sheikh Brothers Investment Limited, where it was held that the court could always allow a party to reswear and reduce or redate an affidavit, as this would not go to the jurisdiction of court under Section 8 of the Oaths Act. My lord, my last one is that, therefore, be pleased.
Has the court been availed?
My lord, that's the leave I am seeking.
You will deliver to the registry the process it undergoes.
It's a minor taking.
You roast it in the oven.
My lord, I undertake before.
But before you conclude with that, does the authority also say what may go with the word of learned counsel from the bar? You've told me there are rectificatory procedures which we can pass. Whoever saw it, come and have it corrected. You can ask for an affidavit which explains that was an error. But does it also say you can just rely on the assurance of learned counsel?
It does not say.
Where counsel might say, my lords, trust me. Does it say?
It does not say, my lord. It only reserves the discretion of court to rely on its own integrity, and that's how I gave the answer, that by virtue of the integrity of the process of this court, it was certainly not possible to indulge in the three hypotheses, my lord.
Honourable Counsel,
Yes, my
I
lord.
don't know whether I missed your response, but I heard the respondents' counsels, at least two of them, saying that the amendment which you are seeking leave of is actually introducing a new cause of action, and you have introduced new grounds. What do you say about it?
My lord, the cause of action in this case is constituted by two complaints. The first is that there was non-compliance. The second is that there were irregularities. Anything else?
So are those new causes of action? That's not my
No,
question.
my lord. No, my lord. There may be new grounds, and they are there. But the cause of action certainly doesn't change.
Thank you.
Yes, Counsel.
Yes, my lord.
A number of authorities have been cited by your brothers,
Yes.
suggesting that in election petitions, amendments are not allowed. You have not commented on those authorities. Do you agree in your
I certainly respectfully do not agree. That will depend on, one, the set of circumstances of a particular petition and the statute under which the petition is brought. In our jurisdiction, my lord, it is not outlawed. And my submission anything that is not outlawed is actually permissible. And that's why you go to the general practice as provided for in the Civil Procedure Act and the Civil Procedure Rules. The makers and framers of the presidential election petition rules were aware that they could not provide exhaustively. And that's why they made reference to the existing rules that apply to this Honorable Court. And that's where amendments are permitted.
Thank you.
My Lords, with that, I pray that you find pleasure in allowing the application as
receiving
printed.
instructions.
I have not received instruction. I have received assistance, my Lords, and in my view, yes, I have catered for the assistance being provided. Thank you.
Thank you so much, Lord Council.
No, the question is not for the, not for the petition, it's for the respondent question.
Councillor, you can say.
Thank you.
First for the respondents, and I'm addressing all the three respondents. I noticed that you have filed a joint list of authorities. So my first question is that in all these authorities, and you have cited to us the law and how it is cast in stone with regard to filing. So my question is, in any of these authorities, was the petitioner restrained by the state? In any of these 15, we have similar circumstances because you have cited them to us and you want the court to believe them. So this question can be answered maybe by, since the Attorney General is the most senior, and others can concur or supplement. That's the first question. So, and if not, doesn't that automatically make these cases distinguishable on that point from the application we are dealing with? First, can you listen to me, Attorney General? Can you let me finish the question and then you can make the consultation? The second question I want to again pose, yes, to all the respondents. The Attorney General can take the lead, but others can. It's all goes to all the three respondents. You have all argued that time is of essence. That is very clear in the Constitution, and it's also very clear to all of us. Actually, the time we're talking about is not time for the parties. Yes, partly it's time for the parties, but for the court as well. But against that background, don't you think it would have saved all of us a lot of time if we had just considered this application, so that we can then get to, to the merits? Those are my two questions. Thank you.
Thank you very much, my Lord.
And is it too late? In the spirit of, the law has incorporated the dispute, mediation and all these other principles.
Thank you, my Lord. Thank you very much. My Lord, the Chief Justice, and my Lords, the Justices of the Supreme Court. The direct answer, my Lord, to your question about whether in our authorities there was anybody suffering restriction, the answer is no. There was nobody suffering a restriction of the type that I think you are referring to now. And actually, my Lord, the Chief Justice had asked earlier that in the case of a lacuna, somebody is suffering from a disability, what does the court do? I think that's what the learned...
You are answering your question, you have answered mine. Can proceed to the second one.
No, my Lord, I'm the one answering. So I was just setting the background because That is why, because the matter had been closed, then you said you had another supplementary question. So with your kind permission, I need to respond to you.
The court is time for court to ask questions, not closed until we...
Much obliged. Yes, much obliged, my lord.
We are asking this for clarification.
Sure, my lord. So, my lord, again, unfortunately, the matter is about a constitutional petition, and therefore, our only avenue is to look at all the laws pertaining to a constitutional petition. However, the issues regarding, in this case, the restriction of the applicant's movement were interrogated by the High Court, and the findings were amended. We illustrated this in paragraph 4 of the affidavit. This was illustrated actually in the affidavit of Toriamo Sima Geoffrey and Annexure A of the same, which referred to MC 6 of 2021, Kyagulanyi Ssentamu versus the Attorney General. At that point in time, my lords, the restrictions were found to be unlawful and his personal liberty was restored. He was, however, required to comply with all the rules that pertained to this particular election.
When was it restored? Since you have told us, read that stuff.
Well, it was restored on 21st. On the 21st of 25th, my lord.
That's the date of the court order. Is that right?
Yes. Suffice it to say again, my lord, you see, because the question you have asked, now at the risk of giving evidence at the bar, because how else would I answer that? The restrictions on the petitioner, because I've already said that you asked whether these restrictions were evident in any of the authorities that were given. Now, of course, the authorities need not have specific on all four scenarios with a matter before a court.
Land Attorney General, you have for all the respondents have argued and presented these authorities to us.
Yes, ma'am.
Rely on them to deny this application.
Yes.
And this matter is pertinent.
I agree, my lord.
So if you are going to say, rely on this authority, rely on this authority, and there are 15 of them.
Yes, my lord.
And all the 15, the petitioner, stroke applicant, was not being restrained like we are. What do you want the court to do?
That's what I'm saying, my lord.
Yes. So I'm not asking you to specify whether the respondent, the petitioner was. I'm just saying, what do you want the court to do with these authorities in light of the fact and the order that you are reading to the court?
To interrogate those authorities on the basis of the matter that is before the court. I would like the court to interrogate the authorities on the basis of the election petition, which is the matter before this court. And then, my lord, the Chief Justice, on the question of the lacuna, I'm submitting that, as I said, the petition of number 1, 2016 of Amama Mbabazi found gaps, and on the basis of those gaps, they made recommendations for amendments to the law. Now, this case, my lord, to answer it directly on the question of what do you do with lacuna, for example, is to propose an amendment that could there be an exception in case of a type of disability that is not the creation of the petition, and to propose that amendment. As of now, what we are interrogating is the election petition, my lord. Now, then the second question. The second question will be addressed by Mr. Bianchi. Most obliged, my lord.
My lord, for the first respondent. Yes. Sorry, my lord. What sanitize? Most obliged, sorry, my lord. Just for the first respondent.
More expensive to buy a coffin.
Yes, and I'm in no hurry to die, my lord.
Thank you.
I was going to attempt the answer whether we could have saved court's time by admitting. Oh, yes, all parties.
No, by the way, it's a two-pronged thing.
Yes, Madam.
You could have saved court's time by conceding. You could also have saved court's time by persuading them to withdraw
Yes,
the
Madam.
abandoned application.
So one part of our submission, generally, was that, look, there's a time limit, that in actual fact wasn't under real disability, and so forth. So there is that part. The second part is that the very amendments he proposes are not going to assist this court. The amendments he proposes are matters that were within his knowledge at all times, even before the disability. The fact that the president of Uganda is the president of Uganda is a well-known fact. Everybody knows it. The fact that a certain general was appointed to the army is a well-known fact. It all happened before the election. The fact that we have a program called the Muwonge is a well-known fact. It happened before election. We're simply saying these matters did not arise during the period in incarceration. Then the other one is, if the court is going to consider a petition, should it allow grounds that do not disclose the cause of action? Should it allow grounds that do not meet the requirements of the law? For that reason alone, we are not only entitled to object, but we are helpful to the court to object.
Does that go to the substance of the petition? And of course, do you expect us now to interrogate the merits of the allegation at this stage?
No, in order to interrogate the merits, you must know the case. In order to interrogate the merits of an allegation of bribery, we must know what allegation is made. And we are telling you these allegations are not proper allegations.
You have interrogated for the court.
No, we have interrogated for ourselves. We are responding as representatives or respondents. We are pointing out to the court. Most obliged.
Thank you. My Lord, any other question? Thank you so much, Learned Counsel, Learned Attorney General, and the entire team from the bar. We will retire to consider the matters that have been submitted to us, but in view of the fact that there is strict timeline for handling this petition, we will return here at 4 o'clock today for you to hear from the court.
No, the other one. Down. The camera back. The live video.
Uganda is bleeding, people are dying, we've heard from above, police brutality. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. So much out of our control, whatever's being done around, shooting us without control, but we cannot fight anyone. We are just unarmed citizens, seeking for change in our nation. We only raise our voices high, yearning for change in our country. Our Ugandans got no right to speak of what goes around. No humanity in the government is taking our peace away. Away. Raise our voices to everybody who can hear us and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. Mighty God, we ask of you, hear our humble cry. It isn't easy for us to just dictate away. We are losing our beloved ones, parents and innocent children. The regime has massacred Uganda's their own country home. Uganda bleeds because of them, it sheds tears because of them. You've tortured us in every way, you've taken our peace away. Voices to everybody who can hear us and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. Katonda tukumire, President wafe, Chagulanyi lyesubira tulina mu Uganda yaffe. Abaana bakaba, oh, buli omu asinda, tetulina ssuubi lyonna. Chagulanyi lyessuubi lyaffe, Mukama tuyambe, tuwambe. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. Come and raise our voices to everybody who can hear us and call upon every nation, please offer us some help. We raise our voices to everybody who can hear us and call upon every nation, please offer us some help. We are dying.
We are not going to give up. We are not your slaves, and we are not going to be slaves in our own land.